Welcome to the Art of Arbitration, where we explore the world of ADR. Today, I am privileged to have as my guest Chakrapani Misra, who is a partner at the Indian law firm of Khaitan. Welcome and thank you for joining us.
Thank you. Very happy to be here.
So why don't we start with a little bit of your background? Tell me a little bit about your legal practice and your law firm, which is a very large firm in India.
Sure. So I'll talk about my firm first because it's older than me. So that makes me look younger. And our firm started in 1911 as an Indian firm for Indian business houses. And that was pre-independence time of our country. So we grew with the business houses as they grew and our practices grew. So we started in Calcutta, and today, after 113 years, we are a pan-India, multi-location, multi-service firm, which has grown to be this size. And another fun fact about our firm is that our founding father was also a part of the independence movement and also part of the Constituent Assembly that wrote the Constitution of India. So we are very proud of our legacy. And over a period of time, as I mentioned, these business houses that we started with, they grew to become multinationals. And we have been very happy to and very privileged to hold those relationships for generations now. So that's a bit about our firm. Speaking about myself, I started as a litigator in 1992. So it's 32 years now. And I started as a litigator and I remain true to my initial practice. Back in the days, there was not much distinction between arbitration and litigation and mediation. So it was one big umbrella of disputes resolution practice. So that's what I started with liberalization of our country in 1992, and I mean the economic liberalization. And with that, practices became more demarcated, more nuanced, more focused. So I have seen the growth of arbitration branching out as a full practice, mediation coming up as a practice, and of course, litigation continues. That's in brief about my firm and me.
So as I understand it, your practice is historically more than half arbitration advocacy and the rest court litigation. Is that correct?
That's right. That's absolutely correct.
But what you just said, it seems that younger lawyers coming into practice now, make a choice between whether they're going to practice in arbitration or practice in court litigation. Is that correct?
Yes. So of late, as I mentioned earlier, 1992, our country embarked on economic liberalization where foreign corporations were invited to come and freely set up business and they could bring in money and take out money freely. With that, a lot of practices developed and legal profession also changed drastically. So today, it is very clear to a law student when he joins the bar that it will be if he or she joins arbitration, what it means, or if he or she joins litigation, what it means. So now it has become more focused. So right from the beginning, a young lawyer decides which way he or she wants to go.
Has that choice come because arbitration has grown as an option for national or international disputes in India?
Oh, yes, significantly. Arbitration since 1996, when our new act came, it has grown exponentially. And earlier we used to have a 1940 act, which had a lot of court interference. And 1996 onwards, the new act has completely transformed the scenario. And because of that, the arbitrations in the country grew a lot. And with that, of course, it has attracted more talent and more legal professionals joining the arbitration bar.
You said prior to the 1996 Act, there was court interference in arbitrations. What do you mean by that?
Yes, that's very interesting. So in 1940, we had our first Arbitration Act. And unfortunately, that act, though it was in the right direction, it had every step of the way that it had to require approval from court. For example, if there was an agreement which said that there is an arbitration clause, you had to go to court to get that validated. Once court validated, arbitration could proceed. After that, again, when an award was passed, it had to be given to court to validate. So at every step, there was an interference, and it looked like that court was sitting as a supervisor or as an appellate body in the arbitration. That is why arbitration did not grow as much as it should have. And 1996 Act changed that because it is based on UNCITRAL model. And there it was all broad principles which were universally accepted. They were incorporated in the Act. Arbitration in that sense was freed of court interference. So that was the prime reason why arbitration grew after that.
Is there a difference in, in Indian seated or Indian venued arbitrations, is there a difference in the speed that an arbitration goes forward versus what it would be in the court of law?
So our court system, unfortunately, is very heavily burdened. Court docket is full, and there is a backlog of several years before a suit can see its trial. As against that, an arbitration, it proceeds much faster. And under Indian law, it's probably one of its kind where the Act provides that if it is an ad hoc arbitration under Section 29A, it has to be completed within 12 months. At the highest, you can have another 6 months of extension. So this kind of timeline has worked for speedy adjudication of arbitration, for ad hoc arbitrations. Now, coming to seat and venue, that's again got very nuanced thanks to court judgments and clarity on that point. So you could have your seat anywhere in the world. Seat is not you could have your venue anywhere in the world. But when it comes to seat has a meaning. It means that if you choose a seat, then that particular court, which supervises jurisdiction over that particular area, will be the supervisory court for procedural aspect. So that is why seat is important, because certain courts in India would have more nuanced and more knowledgeable way of dealing with arbitration, while some may not. So it's important.
So let me see if I understand that. So if I'm a European company and I enter into a contract with an Indian company, and I choose Indian law applies, and I choose India's seat in my arbitration agreement, I can still choose a venue outside of India to actually have the arbitration because maybe all the witnesses are there or for whatever reason, and that's still valid under Indian law.
Absolutely. In fact, you may have multiple venues for convenience. If some witnesses are in, say, in London, you could have that, and another set of witnesses are in New York, you could have your venue changed. So that's not a problem at all. And it does not affect the arbitration, or it is absolutely freely allowed.
So what I assume there has to be an agreement to arbitrate between the parties in order to go to arbitration under Indian law, correct?
Yes. So the law stipulates very clearly that agreement has to be in writing, signed by both the parties, or it should be in writing, which by ascertaining exchange of documents. For example, if there are exchange of letters between parties, which clearly establishes an intention to have arbitration, then it is valid. So agreement has to be in writing.
And are there certain provisions that need to be in the writing for it to be valid, or does it just have to be an agreement to arbitrate? Do you need an agreement on seat? Do you need an agreement on law? Do you need an agreement on how many arbitrators, what entity you're going to be in front of, things like that?
So the law provides for agreement in writing. ingredients are advisable to have, but it's not compulsory. So long as it's a clear clause that refers parties to arbitration, rest can be inferred. It is always, having said that, it's always advisable for parties to have these things specified, because a lot of judicial time is spent trying to figure out these things as to the law applicable, seat, the relevant seat or venue, all these aspects. It's advisable, it's good practice to mention it in the arbitration clause, though not necessary.
So if you don't have anything in the arbitration clause say about the arbitrators, how many, from where, whatever, how are they chosen?
So under the Act, there is a provision that one can approach the court, which has jurisdiction over that seat, and ask the court to assist. So court will in that sense appoint an arbitrator, or even in situations where parties have specified that matter will be referred to an arbitrator and they are not agreeable to a particular name, one can approach the court and court will then assist.
And when an arbitrator is either in the agreement or is appointed because you've chosen a particular institution to arbitrate in front of and you follow their rules, who under Indian law gets to rule on whether arbitration jurisdiction is appropriate? Is that an arbitrator decision or is that a decision for a court?
That's a very, very nuanced question, and is very relevant for people to know. So our law and judicial pronouncements provide for the principle of competence, which means that an arbitrator is capable of deciding on its own jurisdiction. So in case of an arbitrator, if it is an ad hoc arbitration, the arbitrator can decide his own jurisdiction. In case of an institution, the institution will frame this as a question of law, and the arbitrator appointed by the institution will again decide whether it has jurisdiction or not.
And generally, what is the Indian law on accepting arbitration rulings or enforcing arbitration rulings from outside India?
So we have a very long history of seeing the arbitration awards coming from different jurisdictions. Starting early days of new Act of 1996, there was court interference and foreign awards did get challenged and they got stuck in court process. However, post, I would say 2009, the trend has been of non-interference. So if it is an award coming from a foreign jurisdiction which is recognized by India, those awards are enforced as if they are the decrees of a local court. There are certain conditions that this award should be final and the appeal period in that local jurisdiction should have been over, and there is like all appeal provisions should have been exhausted. Subject to certain conditions, that award, if coming from a good jurisdiction which is recognized by government, would be enforced as if it is the local Indian court's decree.
When you say recognized by the government, is that based on conventions that the country of India is part of, that particular jurisdiction would be part of, or are there individual agreements between India and other countries? How does India decide which awards will be accepted?
So India is a signatory to New York Convention. So it is basically convention countries. However, there is a carve out for India in India's case where it has to be not only a convention country, but also notified by Government of India to be a reciprocating territory. So there may be a situation where a country is a signatory to New York Convention, but India has not notified that country to be a signatory, in that event, then that award will have to be tested by our courts. In all other cases where a signatory is notified, then that award will come as if it is a decree of the local court.
So you've talked a little bit about the law from 1996. I understand from our prior conversations that India keeps on amending the law to try to make it more efficient, and that it's been amended in 2015 and 2019. That's correct?
Absolutely correct. Yes.
So the government's pretty active in trying to make it a, for lack of a better term, an arbitration-friendly jurisdiction. Is that fair?
Absolutely fair. In fact, the government has gone out of their way to try to soften all the creases in terms of enforcing the arbitration awards and making it an arbitration-friendly jurisdiction. So not only that act has been amended twice, but also judicial pronouncements have been to clear out any kind of doubts to make this more arbitration friendly.
So under the law, what are the general grounds where someone can challenge an arbitration award in India?
So those are all universally accepted grounds, and they're basically modeled on the UNCITRAL model. So it's like, for example, if there is a legal incapacity where party could not have contracted to enter into an arbitration agreement, or the law is against the public policy of India, or the arbitration agreement is vitiated by fraud, or an arbitration agreement is on a subject which could not have been arbitrated, for example, a crime committed. So these are the few grounds where an award can be challenged.
So as a practitioner of arbitration, let's talk about the actual arbitrations for a little bit. Have you seen a trend in India of arbitrators either awarding or not awarding costs and fees of the arbitration?
So traditionally, arbitration scenario in India, especially the ad hoc arbitration scene, was governed by the retired judges. Mostly the retired judges were nominated as arbitrators. And they carried that tradition of the courts. And our courts are very reluctant to award proper costs. So as a result, in initial period of arbitration, the costs were not awarded as much as they should have been as a fair measure. However, over a period of time, it has improved, and now the newer arbitrators, the recent times, costs and every aspect of it is fully discussed, and arbitrators do award costs.
And does Indian law follow the English rule of basically loser pays fees, or is it the American rule, which is generally everyone pays their own fees?
So our laws are basically based on the common law, which is the English law principles. So it is the losing party pays. However, we have incorporated the fair bit of international practice. So cost is a mixed bag. It is, in certain cases, it will be all parties bear their own costs, but general principle is the losing party pays.
So when you say their own costs, are you including fees? Because we have a very strict distinction in the US between costs and fees. Fees are not considered costs under most American laws.
It's very similar. Fees will only be added when there are frivolous applications made, or where the arbitrator feels that you have wasted the other side's time and resources. So in that event, only fees will be considered. Otherwise, it's generally the costs.
So in the actual arbitrations, you talked before about ad hoc arbitrations. Is there a mix of ad hoc arbitrations and institutional arbitrations, or is there generally a preference toward one on the corporate law side in India?
So traditionally, India has been an ad hoc arbitration-centric jurisdiction. A majority of arbitrations in corporate world have been ad hoc. Even today, the situation is not much changed. It is changing now with some institutions coming in and some international institutions and some domestic institutions taking lead. And our courts are generally encouraging corporate houses to consider the institutional arbitration. So the trend is changing, but still it's primarily an ad hoc arbitration jurisdiction.
So let's talk a little bit about the institution. You said some institutions have come in. I mean, that I understand that to mean institutions that are not headquartered in India. So talk to me a little bit about who's come in and what that's been like for practitioners.
Sure. So traditionally, we had the well-known institutions like ICC or LCIA, that in most of the institutional arbitrations, they were the nominated institutions to deliver or administer arbitration. Of late, we have seen a rising trend of SIAC, that is the Singapore International Arbitration Center, and HKIC, that is Hong Kong International Arbitration Center. They have been very active in India, and of late, many international disputes are being administered by SIAC. So that is the trend that we are seeing. And in addition to that, we have Mumbai International Arbitration Center, which is relatively a newer institute, like it was started only in 2016. So that institution is also doing well, and it has got a couple of arbitrations under its name, so to say.
So I understand that India is such a big center of arbitration that the SIAC and the ICC have actually opened offices in India to help service the arbitrations that are brought in that institution by Indian companies or lawyers, correct?
Yes, so it's a big jurisdiction. India is a very big market in that sense. And of late, in fact, if I am not wrong, SIAC's largest user in terms of dispute arbitration and dispute resolution is India. So 90%, or I don't know the percentage, but it's a very large percentage of their dispute has either one or both sides as Indian parties.
And I take it from our prior conversation about seat and venue that if you use the SIAC or the ICC, an Indian-based dispute, you can arbitrate it in Singapore or in India or wherever the parties appropriately choose, correct?
Yes, that there was some ambiguity about this proposition, but that got cleared by 2 Supreme Court judgments. So yes, that is the position, that you could arbitrate anywhere.
And for example, I know your personal practice was about half Indian and half international for arbitrations. Where have you arbitrated cases?
So as I mentioned, I am not exception to the trend. It's most of the recent disputes have been in SIAC in Singapore, under SIAC in Singapore. Earlier, there were disputes which were administered by ICC. So in my own experience, ICC was a great institution where I practiced personally. I represented client before ICC and LCIA. But of late, the trend has moved more to SIAC. So there are matters that I am doing with SIAC. I also trained myself to become a senior arbitrator with ICC, which was a year-long course which I just completed last year.
Congratulations. So you conspicuously talked about 4 arbitration institutions, but you didn't talk about the London Court of International Arbitration. I think some people listening would have expected that that institution would have tried very hard to get work from India. Tell me why or what happened that the LCIA is not an institution that is used by Indian companies very often.
I was hoping you won't pick up on that, but well, so LCIA, the LCIA had a long and very good reputation in India for a very long time. And historically, it was between ICC and LCIA that Indian parties chose one of the institutions. However, few years ago, LCIA set up an Indian office or Indian branch, which they call LCIA India. Now, what happened after that, that many of the corporate houses in their agreements set up LCIA India as institution to resolve their arbitration disputes. Now, post that, LCIA India for some reason folded up. And that led to a lot of confusion here where parties were at a loss whether they could arbitrate with LCIA. The other side was contending that no, LCIA India does not exist, and I had only agreed to LCIA India. So there was a lot of confusion. So because of that, there was some ground lost by LCIA, and that's why it's like little less popular today.
Your experience, you have arbitrated in the United Kingdom and Hong Kong and Mauritius and Singapore, I know. Do you find any differences in the manner or method of the arbitration depending on where you're actually doing the arbitration, or is it really just based on the rules of the institution you're using?
That's hard to find any real difference in terms of rules because all these institutions are doing arbitration in these very arbitration friendly jurisdictions. It has been a very good experience in all these places. Having said that, I feel that of late Singapore has done a great job of streamlining everything in terms of providing infrastructure, in terms of providing the related setup, and an overall mechanism where you feel more welcome to do arbitration.
Yeah, we have interviewed someone from Singapore, and the government clearly has made a choice to try to make it simple to arbitrate within the country. So I think that was intentional on their part, and it's nice to know that their plans seem to work for lawyers in India. One of the items you mentioned before, institutions you mentioned, you said was new, was the Mumbai Center for International Arbitration. Is that generally, as of now, an institution that is resolving intra-India disputes as opposed to international disputes?
So MCIA started out as an Indian institution administering international disputes. It has made strides in that, but still what I understand is that it is still in its growing phase and it administers more Indian cases and is still looking for more international cases to resolve. So that's where it stands.
So under the MCIA, let's just talk a little bit about, and the reason I ask these questions is it's very different in different parts of the world. Let's talk about how you initiate a claim. Do you file a formal claim with witness statements, or do you just file a demand? How does that work if you're initiating an arbitration?
So typically an arbitration is initiated here by raising a claim. And if it is an institution involved, then you write to the institution stating your claim. And then institution takes over by writing to the other side notifying that they have received a claim and their response should come within X time. And then after that, the institution will appoint an arbitrator and then the process follows. That is as far as the institution is concerned. If it is ad hoc, then you again go by the same process. You notify your claim to the other side, notify that you want to appoint so and so as arbitrator. If the party agrees, then the arbitrator takes over and then the directions are given for further pleadings to be filed.
So under the 1996 and amended law, can arbitrators in India order witnesses to appear for the arbitration or for documents to be produced during the arbitration from third parties? How does that work?
So they arbitrate, first of all, arbitrators are free to choose their own process. They can choose their own way. They are not bound by our Code of Civil Procedure or any other statute that governs the procedural aspect of a litigation or a dispute. So they can choose their own procedure. When it comes to summoning a witness or production of documents which are from third party, there is a provision where you can take help of the court. So on application made, arbitrator would give a direction which can be taken to court. And then court will then basis that pass orders and get the summons for whatever is required.
Okay, so it has to work through a court in order to get that information. And are fees for arbitrators determined by the institution, or are they determined? Does each arbitrator have his or her own rate?
So in terms of ad hoc arbitration, it is determined by the arbitrators. However, our act has recently come up with broadly a schedule which decides the fees. So it's based on the quantum of the claim made and etc. and how many number of arbitrators. The schedule recommends certain fees and fees has to be within that range. That is for ad hoc ad hoc arbitrations. For institutional arbitrations, it's as per the institution's guideline. So the fees is decided by the institution.
So when the arbitrator agrees to be an arbitrator, he or she agrees to the fee schedule set forth by the institution.
Yes.
And are there any institutions of the ones you've spoken about that are generally more expensive or less expensive for the parties to pay the arbitrators? Or is it not materially different?
It's different. It's different. Each institute has everybody claims that they are cheaper than the other. But there are different methods they calculate with. Some go by the quantum of the claim, some go by the number of hours spent, or a lump sum fees, or a progressive schedule based on X amount with range bound amount. So it's different.
So we have a couple of interesting, some would say they're interesting, changes, disputes, issues that are slowly working their way through both public policy, the legislative side, and the courts relating to arbitration. And one of them is consumer arbitrations. You buy a phone and something happens and you sue the phone company and they require you to go to arbitration. Does India have consumer disputes arbitrated or not?
We do have arbitration, but I must caution there that we have our Consumer Protection Act, and that's the law and that the full machinery of consumer courts, which starts with the district consumer forum, going to the state forum and to the national forum. So even if one wants to do the arbitration, it's fine. Arbitration is permissible. However, the remedy for the consumer to go to the consumer forum cannot be taken away. It cannot be contracted out. So one may do the arbitration, submit that to the consumer court, or one may not approach consumer court. But that right will always be available to the consumer.
So why would a company force a consumer to arbitration if the consumer still has the right to go to court regardless of the outcome of the arbitration?
They can agree to waive that. They can agree probably a complaint can be filed, or they can waive that in the complaint, or they can come privately waive that right and say that we will resolve our dispute like.
So in other words, a consumer claim will only be arbitrated when both sides really want to arbitrate it. That sounds logical. We also have the issue of what I call mass arbitrations, which are, we have lots of class action cases, and there are arbitration agreements, say with employees, that say you can't participate in a you have to arbitrate, so you can't participate in an in-court class action against your employer. So what has happened is bright plaintiffs lawyers have said, okay, I'm getting 5,000 employees to bring the exact same claim in arbitration, and our arbitration tribunals have been struggling with how to deal with those economically, because if each arbitration is $20,000 to initiate and you file 5,000 of them, you're immediately asking the company to pay a very large check, probably more than the plaintiffs are even asking for. And the plaintiffs realize that can often lead to settlement. So the arbitration tribunals are struggling with how to manage these and to give due process as required under our Constitution to each claimant. And I wondered if India has had any of those issues, or if that's not something that's normal under Indian law.
No, so here is different, and the class action and the class arbitrations have not taken off here. So it's still very disorganized. So these things are very rare and not the norm.
Do you think that an Indian court would allow those type of cases to move forward, or is that just an unknown right now?
So class actions are very much allowed, and they're part of the court process. But arbitrations, it's unusual.
So let's spend just a few moments on mediation. We've talked a lot about arbitration. And I understand that mediation as a process is really growing in India. And I wondered if you'd take a few minutes to explain why we've seen this growth and what it means.
Sure. In fact, mediation is something that is really growing here. And the reason is more cultural, because historically, we as a country have been used to mediation. So there are historical situations where disputes were resolved in a village or in a small place by 5 wise men sitting in judgment. So they would sit together, they will call everybody, they will discuss the matter, and then they will come up with suggestions which will be acceptable. They will keep working till a suggestion is acceptable to both sides, and they will resolve the dispute. So that is something that is, in principle, we know of and we are used to. However, we did not have any codified Mediation Act till the last year. We had one reference, one provision in our Civil Procedure Code which talked about mediation, but that was hardly used. And there were a few Supreme Court judgments which tried to legitimize or which tried to put their seal of approval on mediation process. But it's only last year that we had a proper Mediation Act come in force. And mediation is fully recognizable. One can enter into mediation, one can file that agreement in court, and it is accepted as a valid agreement and acted upon. So mediation is growing, and it's also need of the hour for India, because as I mentioned earlier, the court dockets are very heavily overloaded. Even arbitrations are now taking time, though law has changed and there has been streamlining of timelines of our arbitration. It's still, there are too many cases. So we definitely need another method, another alternate way of resolving disputes. And mediation seems to be very, very useful. In
So
fact,
does the
sorry.
Mediation Act simply allow mediations formally, or does it require them in commercial disputes? I mean, what is the significance of the Mediation Act?
The significance, unfortunately, when the draft was made, the Mediation Act did make it compulsory for every dispute to be mediated before it went to court. However, when the act came out, they struck off the compulsory part. So it is still desirable that parties do mediation. So what Act does is Act provides a process for, it defines what mediation is, how it should be done, what is to be done, what is not to be done. So it is kind of, if I may say, it is more of a guideline and giving legitimacy to mediation process in a formal way. That's what the Act has done. In addition to that, we have one statutory provision which has been brought in our Commercial Courts Act, where every commercial dispute has to go to the mediation before it goes to court, barring just few exceptions.
So you say before it goes to court. So when you file a case in court, if you fall under that mandatory requirement, do you have to say in the complaint that we tried mediation and it failed?
Yes. You have to give details that, okay, parties tried, we initiated and tried twice and it did not happen, or we tried and mediation failed. That has to be mentioned.
So that's very different than here. Obviously, parties can mediate anytime they choose, but mediation as a process is generally done after a case is filed, and it's often done at the order of the court. So court will order a party to mediation at the initiation or at a certain point during the litigation. Do the judges have the authority to do that in India under the Mediation Act?
Yes, it's under the Mediation Act, and even by other powers which they have, they often refer the parties to mediation. They encourage it, like before they go into an argument, they always encourage parties to go to mediation and say that explore if it is possible, and they will frame some timelines for the parties to explore it, and they appoint mediators also. So I am one of the mediators for Bombay High Court. I am on the panel, and many times I receive a request that this is the court directed mediation that you have to complete within next time. So yes, it happens.
So the mediations are not private, they're done through the court system, through mediators that are appointed by the court, which is very similar to what at least our federal courts do here.
That is for the disputes which are before the court. Otherwise, mediation is as private as it can get. One can appoint any mediator. There's no ban on it.
So are there professional mediators in India, like there are professional arbitrators, or people who do both?
No, it's people do both, but you have to train yourself. You have to train yourself by a recognized institution and undergo that compulsory training of 40 hours minimum. And then you have to do advanced courses to remain in the mediation practice.
Great. Well, I thank you so much for your time. Are there anything that we missed that we should know about the practice of arbitration or mediation for companies or lawyers in India?
I think we have covered most of the grounds. Your questions have been very incisive and comprehensive. And I would only conclude by saying that it's in India right now, the entire system is promoting arbitration and mediation. So it's the right flavor, if I may say, for dispute resolution as of now.
And I'm sure that if we have people listening to this who are international lawyers or international businesses. They now know where to look to find help to get an appropriate arbitration agreement if they're doing business with someone in India. So,
and likewise, another expert in US. So
let's hope so. So thank you so much, Chakrapani. I appreciate the time. I think you helped teach us all a lot about the growth of arbitration and mediation in India.
thank you. It's learning for me as well.